When you need a lawyer, how do you find the right one? Contact the Chicago Bar Association.
Whether you've been injured or need a will prepared, whether you're buying a home or starting a business, having the right lawyer is essential. The Chicago Bar Association have lawyers who practice in most areas of law and speak a variety of languages.
Don't leave it to chance. Get a referral to a screened, experienced lawyer. Visit chicagobar.org or call 312-554-2001. The Chicago Bar Association. Se habla español.
Welcome to the Chicago Bar Association's You and the Law, where we provide programming that is educational in nature for the general public on matters of law and policy. We have with us two very special guests, Professors Aziz Huq and Geoffrey Stone from University of Chicago Law School. And at the outset, I'll just do a very brief sort of program and guest intro and turn it over to them to tell you more about themselves. But I want to thank them in particular because over the last several years, they've made a lot of contributions to us at the Chicago Bar Association through a variety of ways, but including, being on these shows where we focus on rule of law issues, broader issues of constitutional democracy. And I thank you both for being here. And with that, and by the way, we're going to be talking about democracy generally and rule of law generally, those two things together. There seems to certainly be some urgency in the bar associations on those fronts. So it's very nice to have them with us. And I'll turn it over now to Professor Huq, who, one more note of background, it was him and he and Professor Tom Ginsburg at University of Chicago, who I think I did the first sort of broader democracy show with them. And it was in part motivated by a law review article and corresponding book titled How to Lose a Constitutional Democracy. And I believe the book is How to Save a Constitutional Democracy. So that's maybe a good place to start because it provides some history on where my head's been, what we've been doing on the show, and also, your contribution. So Professor Huq, thank you very much. And can you share some background about yourself?
Yeah, thank you so much for having us on the show, Michael. I've taught at the University of Chicago for almost 16 years, and before that was a lawyer for a not-for-profit called the Brennan Center for about 5 years, representing people who were detained by the military and also acting as counsel in a number of voting rights cases. Maybe a useful thing as a benchmark to begin with is to identify what the institutional components of democracy are. There's lots of ways of thinking about democracy. There are ways in which political scientists, political theorists frame and discuss the issue. But for lawyers, I think it's useful to isolate those parts of the formal institutional life of a country that are necessary for what we experience today as democracy. And I'd flag three. The first is the existence of free and fair elections. The second is a public sphere characterized by rights of free speech and association that allow for debate and opposition to government. And then third, what I would call the administrative rule of law. And the idea of that is there are certain elements of government. So, for example, election administration or criminal prosecution, which, if they are captured and if they're used by an incumbent party, it's extremely hard to have free and fair elections. And those three elements, I think if one looks around the world at other cases of democratic erosion, turn out to be the fulcrum for either the survival or the collapse of democratic norms in a given country?
Thank you very much. That was a very helpful introduction, and I will tell you, as someone who, prior to law school, has my areas of study were philosophy, political science, and philosophy. I have found your conception, sort of that lens that's that you just described, which is also presented in the previously mentioned law review article and book, very helpful in the sense. And also as a teaching tool, because these are fairly sophisticated concepts, but they're very accessible when they're presented this way. And I think it's a very useful way to analyze a lot of the complexity that we're seeing. So thank you very much for that. And Professor Stone, if you could provide us with some of your background and thank you again for your contributions to this show and the CBA.
Of course, always delighted to be here. I've been a member of the faculty at the University of Chicago Law School for 52 years. I served as dean of the law school and provost of the university. My primary area of expertise is constitutional law. The first point I would like to make has to do with what are the risks that we face in any government, including what we call a democracy. And one of the concerns that the framers themselves were concerned about was the fact that those in positions of authority would manipulate their power in ways that served their own interests to the disadvantage or at least indifference to those of others. And that was not what they aspired to. And the question was, is there a way to avoid those risks or to minimize those risks in a self-governing society? Part of that was embodied in the idea of separation of powers, where different entities, the executive, the legislative, and the judiciary, had separate and distinct authorities, and in theory could not operate without coordination to some degree with the others. But a particular issue that always intrigued me was that the original Constitution, drafted by James Madison, did not include a Bill of Rights. And when he sent his draft of the Constitution to Thomas Jefferson, who was then in Paris as our minister, Jefferson wrote back and said, "I like what you've drafted, but where's the Bill of Rights?"
Right.
And Madison wrote back and said, "Well, a Bill of Rights really doesn't have any effect. The reality is those in power will do whatever they want and will say whatever they do is consistent with the supposed rights, and it'll only lead to dissolution." And Jefferson wrote back and said, "You're forgetting about the courts."
Right.
And Madison agreed with that. And that was, I think, a critical moment in our American constitutional history, because it then became quite clear with the adoption of the Bill of Rights, which Madison put forth, embracing Jefferson's explanation, that courts have to play a critical role, because we cannot trust majoritarian legislatures or executives to represent the interests of minorities or views that they disagree with.
Right.
And that has become a central component of our American democracy ever since.
Absolutely.
And at the present moment, I think we face a potential crisis insofar as the issue is whether our judiciary is going to be willing to protect those rights in a situation in which the national executive, the president, Donald Trump, is clearly willing to disregard those individual rights, and in which the Congress, controlled by a majority of congressmen of the same political party, who thus far have not demonstrated any willingness to stand up to the president, even when his actions seem clearly to violate the Constitution. The key question now is, as Jefferson and Madison worried, would the judiciary be willing to stand up and defend those rights? And if they do so, will the president and the Congress abide by their decisions? And that's really, I think, at the absolute core of the crisis that we now face.
Right. And I mean, there's so much packed in there. I'm just going to pull out a few things just of note. Certainly, when you mention the Bill of Rights, I mean, that does speak to sort of the spirit of, well, there are a couple things there. that you mentioned, there is embedded in the Constitution and the Bill of Rights a distrust of consolidated authority, which an educated populace is supposed to be guarding against. So you mentioned the Bill of Rights, that obviously we're talking, individual liberties too, which is sort of at the heart of the political and moral philosophy of liberalism, which recognizes, in a pluralistic society where may not be able to agree on first principles, but this houses a lot of what makes that work, hopefully. There's also the checks and balances issue, which is structural and which is being challenged at the moment quite directly. I mean, this may be arguably the heart of what's going on in a structural sense. I mean, I'm just throwing that out there. People can disagree with that, of course. But I appreciate you hitting on those concepts. And I'm not sure from the legal perspective, we can certainly enter without getting political from a rule of law perspective and a structural perspective and the checks and balances issue. But anything, we just did a program at the CBA on immigration and due process. And this very much gets into exactly what we're talking about, because there are speech rights at issue, there's due process at issue, which is embedded throughout all of this, and certainly rule of law. So I've got some ideas, but where might you like to start? This is open to either of you in terms of, whether it's a current happening, a recent opinion, how we can kind of get into this, because we're going to wind up, I think, talking about the same themes no matter where we start.
Well, I'm happy to offer an example of how the two aspects of our Constitution, the Bill of Rights that Jeff homed in on, and the structure of checks and balances can interact in ways that are important.
Mm-hmm.
And I think a really both important and, to my mind, difficult and troubling tactic that we see today, and I think that we have not seen in the same way before, is the manner in which discretionary funding authorities that the federal government has are weaponized into means or instruments for suppressing particular viewpoints. Mm-hmm. So I think that this is an issue where there's an intersection between, on the one hand, speech rights. I'm sure as Jeff, clearly Jeff knows much better than I do, indeed is in part responsible for, the idea that at the core of the First Amendment is the prohibition against the government using coercion or the threat of coercion to suppress certain viewpoints. That's called viewpoint discrimination. There's a link between viewpoint discrimination and the scope of discretionary spending power that the federal government has. And we see this connection between the First Amendment question and the structural question of when and how the federal government, when and how the executive branch is obligated to disperse, or when it can withhold funding that Congress has authorized. Note there's the separation of powers question. Right, we see that crisply across a whole series of contexts. Obviously, for people who work at a university like us, the central theater in which this question arises is the threats to withhold funding from a series of universities, starting with Columbia University. Now, notionally, the funding is being withheld on the ground that there were Title VI violations, in particular with respect to anti-Semitism that occurred on campus. But Title VI of the Civil Rights Act creates a set of procedural mechanisms whereby recipients of funds are entitled to notice, a hearing, and a determination of whether they have violated a Title VI norm. And there are statutory structures that limit the extent to which funds can be withheld on the basis of such violation.
Right.
What's striking about the campaign, and I think it is correct to call it a campaign at this point, against universities, particularly Ivies, on the part of the administration, is the fact that it's not just ignored, but what I think is really important is that it has flagrantly and publicly and openly ignored all of those statutory constraints. And I think that one of the really important effects that is perhaps hard to notice initially because one is caught up in the details of the situation. One's trying to understand the particular legal rules that say govern Title VI. There's the question of what's the allegation with respect to anti-Semitism. What in fact has the university done? Has it been even-handed? Has it not been even-handed? What's the evidence this way or that way? There's all of those questions, but they in some way get in the way of. They blur a background fact or a really important background fact. And I think the really important background fact is that the executive in these cases, as in other cases, is moving obviously, consciously, and intentionally in utter disregard and utterly public disregard of the statutory frameworks for action. And I think that public defiance of statutes, which here is directly connected to First Amendment issues, as we see in the kind of demands that have been imposed with respect to both Columbia and Harvard, which focus upon particular subject matter areas which concern choices about faculty, things that go to the very heart of the First Amendment. I think we ought not to lose sight of the way in which the publicness of the legal violation, its flagrancy, is a way of almost acclimatizing us to the idea that the law doesn't count, right? And surely, as lawyers, we should profoundly care that the law counts, not just for its own sake, not just for rule of law sakes, but for our narrow self-regarding interest in having justice, right?
Sure. Absolutely. So yeah, there's a lot packed in there, but absolutely from my perspective, and this isn't an assessment, it's more just my relationship with it. I am attuned to a lot of the First Amendment issues and feel some of it almost viscerally without getting into detail. I've had some experiences, but a certain and that First Amendment, aspect too. And I've always felt is particularly concerning because it strikes at our sort of collective consciousness and ability to think. And it has a major chilling effect in institutions where and actually I'm tempted to kind of bring up just the Forum for Free Inquiry at University of Chicago and why that's so important right now, including, I believe, in the last 6 months, it received a major gift. Which is like a breath of fresh air in this environment. And perhaps Professor Stone, if you could chat about that, because First Amendment, as far as I can tell, I know you've got other areas of focus, but it's been a principal one for you.
Well, I think that in the realm of universities in particular at the moment, the pressure that the administration is placing on universities is dramatic. Universities are heavily dependent upon the federal government for all sorts of research funding in particular, as well as other forms of funding. And as a general rule, we understand that the government has to make judgments. They will give so much money for something and less money for something else. And we assume those are reasonable judgments, and there's not much one can do or say about it. But in the current situation, what's pretty clear is that the government is doing this because of their opposition to the particular First Amendment activities of public universities.
Right.
And talking about withholding hundreds of millions of dollars of research funds is staggering to most universities. Harvard is rich enough to be able to cope with that, at least for a while, and therefore bring a lawsuit, which I believe it will win, and that will be very important. But other institutions have been just daunted by this, and rather than refusing to comply, they will agree with the demands.
Sure.
What will be interesting to see is as I said earlier, assuming Harvard and the law firms who've sued, because they also have been denied uh, funding and business by federal government because the administration disagrees with their behavior.
Right.
And they just recently won, at least at the district court level, one lawsuit. The question is, as those goes forward, as I said earlier, will the administration comply with these decisions? I mean, I have no doubt that although the government has a good deal of discretion to decide how much money to give X, Y, or Z university, or whether to employ a particular law firm or not employ a particular law firm for certain matters. And for the most part, we don't think of those as constitutional issues. What we're now seeing is a situation where the government is doing these things clearly because of their disapproval of the viewpoints that these universities and these law firms are putting forth. And as I said earlier, the key issue is I think the courts, at least the lower courts, will tend to find in favor of both the universities and the law firms. The key question is what the United States Supreme Court will do faced with these issues, partly given the makeup of the court, which is obviously on most issues extraordinarily conservative. Will they be prepared to disagree with the Trump administration? I have little doubt that 6 or 7 of the justices, in principle, would agree that these actions are unconstitutional. But the question they'll face is, will they be prepared to rule that way?
Right.
And my fear is that they will be reluctant to do so because of the concern that if they do, Trump will say, screw you.
Sure. Right.
What are you going to do? How are you going to make me give this money? And that fundamentally threatens the very nature of our democracy and of our national structure. And I think the justices will be very uneasy about putting themselves in that position. So I think this is a real crisis.
Yeah, it does seem that way. I don't think I'm saying anything new, sort of touching on some themes, but it does seem like, in a very basic sense, this feels like an expansion or attempted expansion of executive power, and it's to the detriment specifically of the judiciary. I mean, among other things, but right now that's what we're talking about, and that obviously should invoke all lawyers' concern, both for the public and even sort of even if it's just a personal self-interest, those things ought to be aligned here, I think. And we are seeing some reaction, I think, broadly through the ABA and the bar associations. I wanted to kind of toss this out here just as an idea and it also just tracks with what I've been doing on these programs, which certainly I think there's an escalation of this type of stuff with Trump that I haven't recalled seeing, in my adult life, or ever for that matter. But even before that, even with the Biden administration, we had done some programs on speech issues, and I think that this is just my own take, and I'm not necessarily looking for it to be endorsed or anything like that, but more of a discussion point. I do see some, and for example, Missouri versus Biden is a case that's sort of interesting in terms of the information landscape and social media companies and their involvement in speech issues, even during the Biden administration. So I feel like we saw some of this leading up to it, and without getting in great detail, even some issues around the election and the manner in which there was not a primary. And we don't have to get too into that, but I feel like it's a bipartisan issue in the sense that everyone should care about it. And I think there are roles that anyone I think if we look at purely through a partisan lens, we might miss what's happening structurally. But without question, there's been an escalation. Does that sort of make sense?
I think that's fair as an assessment. I think that the with respect to the speech issues, I see 2 problems, and I see a tension between those 2 problems. On the one hand, the current digital speech public sphere, the platforms that are on which many of us receive our news and then interact with others, are in many cases structured in ways that distort or filter the information that we receive and the information that we channel in ways that are, I think, highly destructive of democracy.
Right.
I think X is probably the most obvious example here, where there's now a number of studies by computer scientists showing how X now amplifies not just its owner's voice, Musk's voice, but also voices that are ideologically close to him, and suppresses criticism of him.
Right.
So that is, notwithstanding his claims about being a free speech absolutist, this is a structured public sphere in which there is a very, very sharp bias with respect to some voices and against others.
Right.
And that's not the only problem, but it is symptomatic of the problems that arise in a privatized public sphere where ownership is relatively concentrated.
Right.
So the privately owned elements of the public sphere have these structural problems. On the other hand, as you know, when the government starts to interfere in the operation of the public sphere, whether it's for what might be regarded as public-minded reasons, for example, the Biden, the Missouri case that you mentioned concerns COVID misinformation. And I think it's plausible to say that the government's aim in that case was to limit the number of Americans who died from COVID. But nonetheless, it was efforts to manipulate the speech environment. When the government...
I'll stop you just for a brief minute, because we're at 2 minutes. And we've got so much that we got into, so time flew. But
I'll just say that we're often caught between a rock and a hard place when it comes to public problems and private problems with respect to speech.
Sure. Professor Stone, some closing thoughts.
I think that the world in which I grew up, most people got their news and information from ABC, NBC, CBS, which were subject to the fairness doctrine and which were reasonably fair and balanced as they were required to be by law, or by, for the most part, relatively mainstream newspapers. And therefore, there was a reasonable sense of understanding on the part of people about what the different issues were and what the different perspectives were. Today, as Aziz has pointed out, individuals are receiving information from much more radically divided sources, and they don't know it, and they're not aware of it. And that's really dangerous. That's threatening to democracy. And one of the questions, I think, is whether there's anything that we as a nation can do to try to rectify that. In the same way that Congress did when they created the Federal Communications Commission.
Right.
The issue is there something like that we can do today, in addition to education, that makes people understand that they are being manipulated in ways that are not in their own self-interest?
Sure. Well, I really appreciate it. I mean, the best that we could do right now is talk about it and get some insight from people who've dedicated so much of their time and profession expertise to it. So thank you both for being guests on this episode of You and the Law.
Thank you for having us.
All right,
Thank you, Michael.
And thanks for tuning in, everybody.